Hello, I'm Tom Cross and welcome to Cross Examination. I'm a barrister in London working on cases with cultural, moral and ethical importance. In this podcast, expert panellists join me to take an independent look at the law surrounding one of these issues. When James Farrar started working as an Uber driver nearly a decade ago, he thought of himself as the archetypal gig economy worker, benefiting from the freedom and flexibility inherent in not having to work at set times. But not before long, one Saturday night, he was the victim of an assault by a passenger. The police asked him who the passenger was, but he didn't know, and Uber didn't tell him. So he started to look at the legal nature of his relationship with Uber. Many years later, he found himself in the UK Supreme Court, arguing through his lawyers that an employment tribunal had been right to find that he was what is technically known as a worker, one type of category of person with certain rights in employment law, including to the minimum wage and statutory holiday pay. His case has been seen as a victory for the little person over giant and faceless corporations, characterised as seeking to avoid employment law obligations to which they are or ought to be subject. But the decided cases are not all one way. The Supreme Court has more recently decided that Deliveroo riders were not workers, applying the same definition, and even when taking account of their human rights. So what is the employment law applicable to those working in the gig economy? Does it suitably cater for the position of those preferring or perhaps having to work at will? And what might the new government do about it? Cross-examining with me today are, as always, two of the country's most expert lawyers in the area. Colin Leckey has been a partner in Lewis Silkin's employment team since 2012. He advises employers from a wide range of industries on all matters under the employment law sun. But for today's purposes, he has a particularly keen interest in employment status issues and the rapid rise in recent years of the gig economy, acting for a number of platforms, most notably Deliveroo. Hi, Colin.
Hi, Tom.
Paul Jennings is a partner and the head of employment at Bateswells. Most of his time is spent advising employers and senior executives, but over the past 10 years, his team has been involved in a number of the leading gig economy cases, including successfully representing the test claimants in the case against Uber in the Supreme Court. His recent work in the gig economy has involved cases looking at the use of AI and automated decision-making. Hi, Paul.
Hi, Tom.
My third guest today is James Farrar, an Uber driver turned major campaigner for the rights of gig economy workers. Let's start by listening to what he told me about what happened when he worked as an Uber driver and how he became interested in his employment position.
I started working for Uber in December 2014, January 2015. I was the archetypal gig economy worker. I thought that this is something that I could do on the side while I started an NGO social venture that I was interested in doing. And unfortunately, within 3 months, I was assaulted on the job. And that's what began this long journey with litigation with Uber. It was a Saturday evening. I was coming from a journey from Canary Wharf up to Shoreditch. Some very drunk passengers. I needed to end the journey, and I became the victim of assault. And it became kind of dangerous because some of the bystanders thought that I was the aggressor in the situation. I wasn't, but they had wrongly interpreted what was happening, and I needed to go to the police to report the incident because of that risk to me, that if the passenger made a complaint or anybody else made a complaint, I needed to have it on the record. So I went to Bethnal Green police station and made a complaint, and they took the details. And the next day they called me and said, well, look, can you give us the details of the passenger, your passenger? And I said, well, I don't know who the passenger is because, I work for Uber. So I contacted Uber, and Uber didn't want to tell me who the passenger was because it was their passenger. And they promised to get in touch with the police, but the police were in regular contact with me and told me over the course of 10, 12 weeks, Uber was not cooperating with them to identify who the passenger was. And in the end, sort of police asked me, look, if you're not keen to make anything of it, because I wasn't, and Uber not providing us with the information, so shall we just drop it? And I said, well, actually, no. If it's something or nothing, it needs to be something. And I started to try and understand why it was that Uber was not identifying the passenger to the police, whether Uber were not cooperating with the police. that's when I looked at the contract for the first time. Before, I had signed the contract by simply clicking, like we all do. You open an app and you click, I agree, I agree, I agree, and you go to work or you use the app. And I began to understand what was happening. Um, it was clear that Uber was setting itself up as a third party to what was happening. That the contract was actually between myself, or that's the way it was framed, between myself and the passenger, and Uber was simply a agent in the middle. And I could see that they didn't want to get involved because they didn't want to express any kind of duty of care for me. But at the same time, they didn't want to really express any duty of care for the passenger because they didn't want to incur any public liability either. They wanted to make sure that the liability stayed between me and the passenger, so that they would have no duty of liability to the passenger or to me. That became clear. So I didn't really conceive it as an employment issue at first. And I started talking to a lawyer about it, and they went away and researched it and called me about 2 weeks later, 2 days later, and said, "Well, look, you don't really have any rights here, in terms of duty of care, of safety at work from Uber, but you might be a worker." And that's when the journey began, that I may be a worker. And it was that wake up call in understanding, this failure to cooperate with the police, the failure to cooperate with me on this issue that started this.
Colin, James mentions there that he was told by a lawyer that Uber didn't owe him a duty of care in terms of his own safety, but he might be what's called a worker. Just help break that down for us to start with. In employment law, there are different types of status, one of which is worker. What are the basic types of employment status that exist?
Yes, well, we like to make things complicated for ourselves in this country. We have three different types of status in the labour market. We have the sort of full fat, full blown employees. We have the semi-skimmed workers, and then we have the sort of the skimmed, fat free, self-employed independent contractors. And all of the sort of status litigation that we are going to talk about really involves boundary disputes between these different categories. And why does any of it matter? Well, because it affects the types of rights that you have under employment law. So, for example, if you are a full-blown employee, you get all of the rights. So you can't be unfairly dismissed, you get redundancy pay, you get family-friendly rights and flexible working and everything else that that derives from statutory employment protection. If you are a worker, the middle category, you get some rights. So you're covered under the discrimination legislation, the whistleblowing regime, you get rights to minimum wage and holiday pay, but you don't get some of the other rights that I mentioned that are the preserve of employees. And if you're a self-employed independent contractor, you get very limited employment rights indeed. So how do you determine who falls into what category? I always like to remember that before any of us were practicing, employment law was known as the law of master and servant. And I think it's a good way of reminding ourselves who an employee is. You know, the servant serves the master. So employees are people who have contracts of service.
Yes.
And we have this concept of mutuality of obligation. So the employer is obliged to provide work and the employee is obliged to do it. They have to do it personally. They can't send someone else along to do it for them. They are operating under the supervision, direction and control of the employer. And in all other ways, they're sort of tightly integrated into and part of the employer's organisation. Who are workers? This is the middle category and the one to which James was referring when he got his legal advice. So these are people who aren't quite full-blown employees because, for example, often they don't have mutuality of obligation. They're not integrated into organisations as tightly, but they are nevertheless people who undertake to perform services personally. And that's a key thing. And we'll talk about rights of substitution later, for someone who isn't a client or a customer of a profession or a business undertaking operated by them. So that's why, in terms of that latter part of that definition, your plumber who comes to your house to fix your leak for you isn't your worker. You might well want him to do the job personally. You probably do, because he's 5-star rated on Checkatrade and you don't want his mate from the pub to come along instead. But he's running his own business and you're a customer of his business. So he's not your worker.
And that definition of worker is a statutory definition that's found in lots of different statutes, actually, because they correspond to different rights that workers may have. But it's broadly the same definition across the different
Broadly
statutes.
the same, yeah, no, that's absolutely right. You get the odd word that's different
Yes.
here and there, don't you? It's slightly strange sometimes, but essentially, you know, that definition applies across all of the laws that are relevant when we're disputing cases in this area.
And what are the issues posed by the so-called gig economy at large, Paul, is whether, as Colin says, people who sign up to, I suppose, sporadic work that's made available through some platform or other, such as Uber, Deliveroo, etc., are workers. Now, in James's case, Uber was saying that the contract between them and the driver was not for the driver to do work for them, for Uber, but rather for the driver to do work for the passenger. So they were saying that's the key contractual relationship, if you like, and Uber was just the booking agent in the litigation. That's how the battle lines were drawn in terms of the arguments being adopted by both sides.
Boundary lines are the key thing here. So in all of the gig economy cases, what is happening is there is an argument around where that line is drawn and which side the individual falls on. And in most of the gig economy cases, what the employer is trying to do is to say this individual is self-employed.
Yep.
And there is a narrow commercial attractiveness to arguing that, because if you don't have to worry about paying the national minimum wage, if you don't have to worry about regulating working time, if you don't have to pay for holiday pay, that is very liberating for a business. And you don't have to balance, for example, labour supply with demand in the market, and you have a bank of people ready and willing to work to whom you owe very little responsibilities. So that is a commercial advantage, and that drives these disputes. Uber, in this case, tried very hard. They bent over backwards to define the relationship so that it would sit on the self-employed side of the boundary. So they asserted that they were not a transportation company, that they were a technology company in the business of lead generation.
Yes, they were a lead generator, they said.
They were a lead generator. They said that they had no contract with the drivers, aside from the drivers signed up to a contract with a Dutch parent company, but that was more about IP and technology. The work on the ground, they said that there was no relationship between Uber London Limited, the regulated license holder, and the 40,000 drivers delivering the work on the ground. And they said that the key contract was between the driver and the passenger. And obviously, intuitively, if you're a passenger, you're catching an Uber, you're deriving some reassurance from the fact that it's a brand with standards. And if you're a driver, you probably think that the contract exists with Uber. So there was a degree of incredulity on the part of the judges, I think, accepting that there was the absence of a contract altogether.
Because the contract, as it were, said one thing, corresponded to the features as Uber wished for the matter to be presented and to appear. But from the driver's perspective, they were saying, of course, the reality was very different. They weren't working on their own account. And in reality, they had a contract with Uber for all sorts of different reasons that they gave. That was their case.
Exactly. And there was a real tension between the reality, as anyone would have seen it, and the way that the documents constructed the relationship. So just to give you an example, as I say, Uber London Limited was operating within a regulated space. It had 40 to 50,000 drivers. It hired them, performance managed them, disciplined them, dismissed them, and exercised vice-like control over the way they conducted their work. So the suggestion that there was no contractual relationship between the body that was regulated and the drivers that sat under them just had a strong air of artificiality.
Let's hear James's account of the experience of trying to establish his status as a worker.
The hardest bit about it at the beginning was gathering all this evidence, and we had loads of evidence at the time, lots of messages. So it's beyond the contract. So the contract was one proposition. Our job was to work with the lawyers to prove that this contract was completely artificial, that this is not how things really are. Because that's what's required. The burden of proof is on us. The burden of proof is on the worker when you go to court to prove that your relationship is other than what the contract says it is. Somebody once described to me that employment tribunals, employment is a relationship like any other. And that's why there's sometimes a lot of emotion in employment tribunals, but you're having to prove, imagine having to prove that you're in a relationship with somebody and the other person decides that they want to deny that relationship exists. Imagine that relationship in a romantic setting or a family setting even. If somebody is denying that we have this relationship. And that's a tough, in a way, it's a tough psychological journey to go on. I have to gather all of this evidence to prove that I was in a relationship of control and in a relationship of abusive control, frankly. So that was the first initial bit, is to gather that evidence, to gather other supplementary evidence. There was a famous a famous submission made to the London Assembly by Uber, which completely turned on its head the proposition that it was telling to us. So Uber has this very awkward language. It won't call it a job. This thing you're a partner was one language until they started doing their IPO, and then they thought maybe we better stop the partner language because it might have to give us some shares in the business. And now they've settled on this term, the economic opportunity to earn. So now on the Dara Khosrowshahi, the CEO, calls the workers earners. They won't call it anything else other than a job or work or workers. But at the London Assembly, they were boasting to the London Assembly about all the jobs they were creating. And of course, we found this document, which was, what they were presenting in one domain was completely different to what they were presenting to us. I think our barrister described it as speaking in forked tongues, which is something the Guardian picked up on. Going to tribunal was a bit daunting because, I had to take the stand, and so did other people as well. We had to give our evidence, and we had to be cross-examined, and that cross-examination can be quite tough. But there was a moment, when I knew that we were probably going to win it. It's intimidating because on one side, there was a bunch of us drivers, and we were there in comfortable shoes and crumpled suits from driving and tired. And then the other side, you had this very glamorous, suntanned Uber executives on the other side. And the senior Uber executive got on the stand, and I heard their voice crack, and I thought, oh, we might win this. And it gave me the confidence to understand that it doesn't matter how theoretically, I mean, I think the system, although I'm cynical about the legal process, it is true to say, having gone through this, it is true to say that it doesn't matter how much money you have. It doesn't matter how bright your lawyers are. If you're wrong, you're wrong. And that was the situation, I think, with Uber. They had expensive lawyers. They had a lot of money to throw at this. They had a lot of money to resource to throw into this. But I'm afraid legally they were wrong, and we were right, and that made the difference.
This question of language ends up being very central to the Supreme Court decision when this case goes all the way up. Employment Tribunal, appeal courts, and then up to the Supreme Court. What did the Supreme Court decide? Where's that left for law?
Well, language was a recurrent theme. And if you read the judgments from first instance all the way up to the Supreme Court, what you detect is a level of irritation on the part of the judges. There is a tendency for businesses trying to manipulate a boundary and place someone on a side of a boundary line that is favourable to them to work on contracts and to use synthetic language. And one of the points made before the Supreme Court is that it's a bit like a piece of wood. It doesn't matter how much varnish you put on it, the grain tends to show through, and that's what happened here. There's all of this artificial language, but in reality, when you drilled into the relationship, the contracts didn't reflect what was happening on the ground. And what the Supreme Court said is that these are statutory rights. The public policy underpinning the statute is the protection of people who are vulnerable to exploitation. Yeah. They may be required to work excessive hours, they may be paid too little. And statute steps in and interprets that relationship. And it doesn't matter if lawyers fine-tune agreements to try and manipulate a boundary. The courts need to look beyond the contract at the reality and come to a conclusion that is within the spirit of the statute.
So the legislation, if you like to put it simply, trumps what's written down in black and white in the contract. What were the features of the case that weighed with the Supreme Court in particular that highlighted that for them the conclusion should be that the key contract was between the drivers and Uber?
What they said is the contract is not the starting point. It's one piece of evidence to be weighed in the context of the full relationship. So they looked beyond it. They looked for the true quality of the relationship and then came to a judgment guided by the purpose within the statute.
Let's talk about the other major Supreme Court case in this area that you were involved in, the Deliveroo case. You explained earlier that a central part of the definition of worker that applies across different pieces of legislation is that somebody's got to do work personally. That's actually the word that's used in the legislation. But that wasn't the position for Deliveroo riders in that case, was it, who brought that case? And therefore they were needing to rely on a different type of argument, in other words, a human rights argument. How did that case come about?
Yeah, that's right. Well, the first thing this is a slightly unusual status case because most of the cases like Uber that we've been talking about and most of the others that get reported are claims in the employment tribunal for things like minimum wage and holiday pay and other rights that go with worker status. This was a slightly different set of proceedings. It was an application by the IWGB trade union for compulsory trade union recognition in respect to a group of Deliveroo riders who they said were workers.
And recognition means what in practice, if you get recognition?
Yeah, and if you're recognised, you have rights to engage in collective bargaining with the putative employer about a range of topics, but in particular pay, hours and holiday. They're sort of the key ones under the legislation.
So it forces them to come to the table, even if not
yeah.
actually have a particular type of agreement. You must sit down, as it were, with us and talk to us.
Exactly, sit down and have that conversation and have that discussion. The starting point is that the individuals have to be workers. So we go back to that test. They have to be people who undertake to do work for you personally, and those people aren't clients or customers of your business. In this case, the IWGB union was unsuccessful on account of the fact that delivery riders didn't have to do the work personally. So Paul has made the point rightly that in these cases, what matters is the facts on the ground and not what it says in the contract. And here, a number of riders came along, gave evidence of their usage of substitutes. So they sent along people to do deliveries on their behalf for a range of different reasons, which led the Central Arbitration Committee, which is the body that decides these disputes, to say that the central insuperable difficulty for the union's case was that the riders did not have to perform the work that they did for Deliveroo personally. So this isn't a sort of contract versus reality case. So that's the decision at the CAC, but it goes up through the system like the Uber case. It goes to the High Court, it goes to the Court of Appeal, it goes to the Supreme Court. The High Court says there are various different grounds of appeal, and the High Court says, well, all of the domestic points of appeal are not arguable, but what you can have a go at is a point under human rights law. So Article 11 of the European Convention on Human Rights, rights to freedom of association, and the IWGB says, well, regardless of what the domestic statutory definition says, you need to read that in the light of case law of the Human Rights Court in Strasbourg, which we say means that you have to view delivery riders as people who are in an employment relationship with Deliveroo.
Right, so UK law is saying you need to do your work personally. The contract says, and the Central Arbitration Committee finds, that actually they didn't in reality. That was the position under UK law, but the argument was, what about human rights law? Article 11 of the Convention gives us, so it was argued, a right to collectively bargain with Deliveroo in the circumstance of these riders, even though that was the position on the ground. Human rights law requires that to be set aside, and we have a right to collective bargaining nonetheless.
Absolutely. No, that was precisely the argument, but the various appellate courts said, well, it doesn't. And in fact, when you look at the case law from the Strasbourg court, actually, it doesn't give a right to collective bargaining to people in the position of the delivery riders. And in fact, the UK Parliament was entitled to restrict access to the mechanism for compulsory collective bargaining to those people who performed work personally. So, in other words, who sat within that domestic statutory definition of a worker. So Deliveroo wins all the way up to the Supreme Court.
I suppose, Paul, one feature of actually both of these cases is it's not right to take from them the general proposition that if you work with Uber, you are always a worker, or that if you are a rider for Deliveroo, you're never a worker. There may be subtleties depending on the factual situation that's applicable. So that if Uber, as indeed they subsequently sought to do after the Supreme Court case, sought to change its operations in certain ways to meet the points that the Supreme Court was making, it would wish to potentially argue in a different case, actually, there isn't a worker relationship with new drivers.
That's right. I mean, it was difficult for Uber to say that the Supreme Court decision was in some way restricted to a subset of workers. But that's because of the regulatory framework within which they were working. So that there couldn't be any substitution. These riders needed to be identified. They had identity cards. So there was no opportunity to substitute. And so I think when the judgment initially came out, there was an initial attempt to say, well, yes, we fought it for 6 years and we fielded a fleet of lawyers and spent a fortune, but actually it only relates to 30 drivers. They quite quickly abandoned that, accepted that it applied to the 50,000 drivers they had, and paid significant sums in back pay. And then they moved on to, I think, trying to address the problem more comprehensively by paying pensions, paying the national minimum wage, providing holiday, providing access to training. So in that case, it was an organisational wide impact, but certainly there's room for nuance. And the problem with the system is that the case was first litigated in 6 years prior to the Supreme Court decision. And what can happen in that intervening period is that the business model can evolve and the new arrangements may not fit with that judgment. Yes. So the facts move faster than the law, unfortunately.
But I suppose the point is that you might have a different model. You might have a model where, in contrast to the position with Uber, drivers can charge what they want rather than the amount being set by Uber, where there was a freer relationship between the drivers and the passengers, where drivers weren't, as you mentioned earlier, sanctioned if they refused to take 3 jobs in a row. The point is, though, it wouldn't necessarily be Uber. It would have to be a different type of model altogether.
Yeah, and I think Checker Trade and those types of models, it's a platform, it is lead generation, but once the plumber or the tiler comes to your house, you're negotiating with them. There's no realistic argument that person is in some way at work or independent in a dependent work relationship. They are genuinely self-employed. So depending on how the model is configured, you can have very different outcomes.
I mean, stepping back here and thinking about the position philosophically, I suppose the big value that proponents of gig economy models argue for or rely on is freedom, flexibility, the flexibility which it allows people as to when they work and to how and as to how long they work for. An employee, as Colin was explaining earlier, in the traditional master-servant relationship doesn't have that flexibility. It's the opposite of flexibility on that kind of classic model. I suppose the law to some extent reflects that by giving fewer rights to workers than employees. But I just wonder whether there's a flip side to flexibility or freedom which the law might not be thought to take full account of. I asked James Farrar about that.
What's at the heart of the problem of the gig economy, and the gig economy can never be properly addressed until working time is addressed, is the fact that you've got so many people waiting to be assigned a job, to be waiting for work. And that's the only way that this on-demand model can work. And that people can perceive that I can touch an app and have a car show up in 90 seconds. The only way that's possible is if you have far too many people waiting for too little work. That's the only way that is possible. And that I'm afraid is a terrible tragedy, because it creates congestion, it creates poverty, it dilutes your bargaining power with the employer. The whole premise of being flexible to work when and where you want. The flip side of that is that it literally doesn't matter whether you come to work or not. They don't care. You can come to work, you can have flexibility, but we don't care if you come to work or not. And because we don't care whether you come to work or not, you have no importance to us in terms of we can sling you off the app at any time, and they do. And the rates of dismissal are very high. And we can pay you as little as we want because you've got no bargaining power. So I'm afraid until this issue of unpaid working time is addressed, a lot of the problems of the gig economy will continue. But I'm optimistic. I'm optimistic it can be solved again with the same combination of litigation and campaigning. But that's a battle that's still ahead of us.
Paul, James's point really is about the fact that the gig economy relies on people waiting for work, but there are consequences of waiting for work. There might be financial consequences. Goes to an argument about whether or not you should get paid for the waiting bit of the work. But it might not just be financial consequences. There might be health consequences. The consequence may be that you work for an employer or a putative employer who you feel, in James's language, doesn't care about you. These are broader consequences than the narrow technical position that we've been establishing today. I wonder whether you feel that the law does or needs better to grip that problem of the flip side of the flexibility.
Yes, the common law is flexible, but there is a problem, and you only have to walk past a large McDonald's and you'll see a bank of bikes, people waiting for work. I also think it's a bit of a madness that you can have big companies, so companies that are listed or about to be listed, who employ tens of thousands of people, and the onus is on an individual to carry that forward and to live through it for 6 years. It's too atomised, and maybe where there are large-scale manipulations, there needs to be a more centralised response to it.
But there is, Colin, isn't there, a great value to flexibility? One of the aspects of the evidence in the Deliveroo case was exactly how popular Deliveroo is. And it doesn't take long to find statistics to see how popular all sorts of gig economy work is. You've got hundreds of thousands of people queuing up to do this work. It can't all be bad in their minds or unattractive in their minds. There's a real value, nevertheless, to flexibility that people, perhaps particularly post-pandemic.
Yeah, no, that's right. And there are certainly tensions between, sort of the degree of flexibility that gig economy models permit and the extent to which it's possible to address some of these issues around working time. And I think this issue of waiting time is quite an interesting one in this context, because in order to maximise flexibility, and at the heart of a lot of gig economy platform models, and with the caveat that each has to be assessed on its own merits, and the facts that underlie each will not always be the same. But is this idea that you can decline to do work if you choose to do so? So something pops up on your phone, says, do you want to pick up a delivery from Nando's for £3.50 or whatever? You can say nope, don't fancy it, and swipe right or whatever it is, and say no to that. But in order to be given that opportunity, you'll be marking yourself as available to be offered work, or as it might be said, well, that's waiting time, and the argument would be made, well, that's working time. But if it is working time, and therefore time that you ought to get the minimum wage and holiday pay for, there are obvious problems in terms of having maximum flexibility.
Yeah.
The system can be gamed if you could just decline orders without any adverse consequences. And even more than that, there is within the gig economy this phenomenon of multi-apping.
Yes.
So at any given time, someone might be on their phone and marking themselves as available, not just to Deliveroo or Uber Eats or Uber or Just Eat or sundry others, and they'll just be looking out, see, well, what's the next available order that comes along, and if it looks like it might be worth doing, I'll accept it and I'll pick that up. But are they working for all of those platforms during that time? Are they entitled to minimum wage from all of them? Are they entitled to holiday pay from all of them? Now, the argument will be made that by in some quarters that they are, but that seems conceptually difficult. And if that is right, then the inevitable consequence of that is you're going to need to limit the degree of freedom and flexibility that people have, and coming back to that definition of employee, require them to do things.
And now the Employment Rights Bill is something that we're told is coming, according to the King's Speech and the information that's been published with the King's Speech. We're recording this in late July 2024, so the King's Speech has happened. So one of the things the government said it's going to do is, quotes, we're going to ban exploitative 0-hour contracts, ensuring workers have a right to a contract that reflects the number of hours they regularly work. Interesting in light of the discussion we've just been having. And this will end, they say, what they describe as one-sided flexibility, ensuring all jobs provide a baseline level of security and predictability. Paul, that might not just be aimed at the narrow gig economy type case that we're talking about, but it could certainly cover, in principle, the question of the time for which gig economy workers get paid, to perhaps cover the case of the driver who's waiting for a job, is unable in practice to do alternative work, and nevertheless maybe waiting for a very long time because the waiting list's high.
Potentially. My sense is that this will... There's been a long concern about 0-hours contracts, whether they're asymmetric, whether they're exploitative, and in many cases they are, and it's right that the government is focusing on this. I suspect this will redress the balance slightly for those who are employed or those who are workers. I don't think it will do enough to manage the difficulties experienced by those who are classified as self-employed. So it'll be interesting to see how it materialises, but I think it's part of the picture rather than a significant solution.
What's meant, Colin, by the term 0-hours contract?
Yeah, it's one of those elastic phrases
Yes.
that's used in slightly different ways depending on the context and who you're talking to. But typically a 0-hours worker will be a worker, if that's not a tautology, or an employee. So, the starting position will be that they have some basic employment rights, if not the full set of rights, because they are undertaking to do that work for a third party, and they're undertaking to do so personally. So the distinction between at least some of those within the gig economy is that, as we've discussed, for example, in the Deliveroo case, people are on the self-employed side of the divide, because of the absence of the personal service requirement. So they may not have an obligation to work. So in a sort of lay sense, they're 0 hours individuals, and might be thought of that way by many people, but that's not how we typically use the term.
Yes, it may be that Labour's talking here about the situation where there's a clear acknowledged employer, and the point is there's no dispute who your employer is. It's just that the employer's saying we don't actually have to give you any work, we'll just pay you when you do that. What about this one, Colin? They say that the bill will make parental leave, sick pay and protection from unfair dismissal available from day one on the job for all workers.
Yeah.
There's a few interesting things to unpick from that.
Well, yeah.
First of all, as you were explaining before, unfair dismissal is something which, at least in the technical language, only applies to employees, not workers.
Yeah, absolutely. So does Labour really mean that it's going to extend day one unfair dismissal protection to everyone who's a worker but not an employee? And what exactly does that mean, particularly in the context of what are, as we've discussed, invariably much more flexible relationships where you're talking about workers? So, for example, if I've got someone who is a worker on my books and they do the odd shift here and there, and maybe they've been inactive for 2 months, and then they do one shift, and they do it terribly. If I decide I don't want to offer them any more work, do I have to go through a disciplinary process, a performance management process, before I can decide not to work with them anymore? I don't know. But these are sort of key questions that are going to need to be answered by Labour if they're going to go down the route of day one rights for all workers.
I mean, it may be alternatively that they're using workers in the kind of broader non-technical sense. They really mean employees, I wonder. And when they talk about rights being available for unfair dismissal, for example, from day one, what they're doing, Paul, is actually reversing the current law that applies on unfair dismissal, which is that you need what's called a qualifying period of employment, continuous employment, in order to be able to gain your unfair dismissal right. You don't have it from day one at the moment.
I suspect that's right. If they were to collapse worker category into employee category and give day one rights, that would be a very radical step. And I imagine the day one rights will be extended to employees rather than employees and workers. And I think the control mechanism will be a probationary period during which people can be terminated without those statutory rights being fully engaged.
I noticed finally an interesting reference, I thought interesting, to flexible working in the material. Interesting because of its obvious overlap with those who'd want to potentially do gig economy work. It's precisely the desire for flexibility that may motivate a lot of people in the space. They say that the bill will make flexible working the default from day one for all workers, subject to what workers means, with employers required to accommodate this as far as reasonable to reflect the modern workplace. Let's just, Colin, perhaps explain that the position at the moment is it's not the default. You have to request flexible working. That seems to be the point that they're...
That's right. You have a right to go to your employer and say, I would like to work flexibly, which might mean a range of things: homework, reduced hours, reduced days, etc., etc. And there's a process that your employer must go through to consider that request. And there are only, I think it's 8 permitted grounds on which they can say no to it. But fundamentally, they can say no.
Yes.
This is a proposal to flip that round and say, well, the starting point is that any request by you to work flexibly should be accepted, and then your employer's got to come up with a good reason, good explanation as to why that isn't possible in the context of their business. So that is an important shift.
There's definitely a shift towards flexibility. People expect it more. Employers are more open to the possibility. And there's kind of 2 gears to it. There's the sort of right to request flexible working, which may become a default, which is not attached to a particular protected characteristic, and there the employer has a wide discretion to say no. But if you have caring responsibilities, a disability, or if there is certain religious observance that's linked to your request, that's a much more powerful right. But these are progressive steps. People want more flexibility, it gives people a better balance, and it is moving in that direction. I think there's a shared will to do that. But these are white-collar entitlements, by and large, and the flexibility that we talk about in the gig economy is much more synonymous with insecurity or precarity. So I think these 2 different types of flexibility don't really mean the same thing.
Well, the black box of worker status in gig economy cases has been fantastically illuminated today. Paul Jennings and Colin Leckey, thank you very much for cross-examining with me.
Thank you.
Thanks.
We've reached the end of the podcast, but we'll be back soon, and we'd love to know what you'd like us to examine next. Tell us what you're interested in or concerned about in the world of law by tweeting at CrossExaminePod or by visiting our website. That's www.crossexamination.co.uk. Remember to follow us wherever you get your podcasts, and if you've got time, we'd love a positive review on Apple Podcasts. It's the best way to spread the word about cross-examination. Meanwhile, I've been Tom Cross, and until next time, goodbye.